So today our topic is pre-action conduct. So in civil cases, um, the second stage is pre-action conduct. After finding out that remediation period hasn't passed away, we have to go through pre-action protocols before litigation starts in UK. There are protocols on pre-action conduct which need to be followed before a claim should be commenced. There are a number of different pre-action protocols designed to cover a variety of claims. For example, for clinical negligence, judicial review, defamation, construction and engineering disputes. Litigation in court proceeding is now seen as means of resolving a civil dispute only as a last resort. This is important. Like litigation is should be taken as the last resort. An alternative ways of attempting to settle the dispute are actively encouraged under CPR. Protocols are designed to improve pre-action communication between the parties and to encourage settlement. So pre-action protocols are designed in a way to encourage settlement before the litigation starts, and it saves the time and money, time of the court and as well as the parties, and the money of the parties which they will spend in the course of the case. You can take a look at some of the pre-action protocols in the CPR and you will see that they encourage the parties to exchange information in advance of commencing proceedings. The aim is that if both parties have a clear and full version of events and facts before them, and the time to reflect that this may increase the chance of settlement. So if both parties see that what are the chances of their winning and what will they get after winning, and if they can get the same kind of a benefit before going to the litigation, so why would they spend time and money in the litigation? So they then will prefer settlement. Importantly, although they are referred to as protocols, they are enforced by the courts. So although they are said to be protocols, they are necessary part of a civil procedure in UK. And a party who fails to comply with the relevant protocol will find that they will face sanctions by the court even if they are ultimately successful. So even if the party gets successful in the litigation and it has not followed the pre-action protocols, they will face some consequences that they might be deprived of the costs, legal costs. For example, they may be deprived of their legal cost or part of their legal cost to which they would otherwise be entitled. So pre-action protocol is that much important that they might get deprived of their legal cost, and if they would have followed the pre-action protocol, they might have gotten entitled to that. Whether or not you may have complied with the pre-action protocol will also need to be referred to on your statement of case. So when you are going to the litigation, you have to tell the court that have you gone have you concluded your pre-action protocols or not, and also in the directions questionnaires which all parties will be required to file if the claim is defended. So this is quite important that we follow pre-action protocols before going into the litigation stage in UK in civil cases.